This is Behind the Headlines, and I'm Pacchia. The ABA's task force on the future of legal education is expected to issue its draft report soon, spelling out what reforms it recommends for legal education. But our guest today says that many of the fundamental tenets of the legal reform movement are flat out wrong. We're joined now by Stephen M. Sheppard, Associate Dean at the University of Arkansas School of Law. He joins us via Skype from London. Welcome, sir.
Hi, Lee.
You recently wrote a critique of Brian Tamanaha's book, Failing Law Schools, and many of your points apply to the broader legal education reform movement. For instance, reformers claim that there are too many law schools, but you say law schools have shrunk over the past 30 years. Could you flesh that out for us a little bit?
Absolutely. And first, I should say, I have a great deal of respect for Brian Tamanaha as a legal theorist, and many of the people who are in the legal reform movement have many valid points. The difficulty is, what do we do with an effort to improve, and how do we decide exactly what our problems are? So yes, many of the premises of the legal reform movement, I think, don't bear great scrutiny, either from a social, scientific, or historical perspective. If one takes not merely the number of students over the last 30 or even 50 years, but takes the number of students in higher education, the number of students in law school has in fact fallen. If one takes not just the number of students or the number of schools for that matter, then what small growth there has been in legal education is much less than the number of people in the United States. So as a percentage of either Americans or of university students or of college graduates, the number of people who enter law school has in fact fallen as a percentage. Whether you look at this from a window of 30 years or 20 years, the number is in fact lower as a percentage basis. I also think it's important to recognize that the law schools have taken on a very fundamental mission, which is to enlarge the availability of legal education during that period. In fact, if we worry about demographics, if we think about the number of women and once otherwise ostracized social groups who are now importantly available to legal education, the number of seats that are available for these once excluded groups dwarfs the growth of legal education. The number of simple white guys who are in law school has fallen.
Another core argument of the legal reformers is that law schools just cost too much. But you say there are more than 50 law schools, including some very good ones, that charge less than $25K a year. Is that enough in your opinion? Do you think the market is adequately serving students who just want a less expensive JD?
Well, one of the difficulties of deciding what a price is that one has to understand what all prices are. I think that it's important to understand that the students who have chosen to pay the prices they pay, even at $50,000 a year, have made choices that they considered valid. And I reject the premise that all law students are somehow too stupid to understand the price of their degree or the cost of their payment. This is very different from my experience of American law students. But it is still true that there are quite a number of legal education opportunities that are available to American law students at half of that price or nearly so. I have the privilege of teaching at one of them. The University of Arkansas offers a very full-blooded legal education. We have an extremely successful alumni, and our tuition is $26,000 a year.
Right on.
Now, if this was all about the price of tuition, one would imagine that our school and other schools of a similar price and value would be bursting at the doors. In fact, as numbers have fallen, we have seen more or less the numbers that come to us slightly increase, but nothing like the increase that would be if price alone, or for that matter, if only jobs alone, were the issue.
Reformers also say that law grads are simply burdened with too much debt. Yet you point out that income-based loan repayment programs allow graduates to cap loan payments at a percentage of their income. But if you can't find a job, or you're laid off from your current job, as many lawyers have been, how much of a solution is it really?
Well, I think this is a fundamental problem, but there are three different aspects to it that have to be better understood in order to make sense of it. The first of which is law school cannot be understood separately from the rest of higher education in America. We have a fundamental problem in America in which we demand that our students somehow become prepared for an information-based economy, and yet they're somehow expected to find that money and take all of the risks necessary in order to invest in their own educations for an uncertain and changing future. Law schools are a part of that, and law schools have a responsibility to every student who comes to them. Yet we can't change the fact that presently federal and state support and private support for study is remarkably low. Thus, students bear this burden in all these fields. The fact of the matter is, income-based repayment makes, for today's student, a much, much lower risk than ever it was when I, for instance, was a law student, or many of the people who studied before me and since. IBR softens the blow and diminishes the risk for students who opt to go to law school, as it does for many other forms of higher education. And failing to appreciate that fails to recognize one of the very few achievements that the executive and the Congress have brought for people who are burdened by debt in order to participate in the American dream through education. It's really fundamental. Someone has to pay for it. Either you pay up front, someone else pays while you're there, or you'll have to pay later on. But by capping the forms of repayment based upon your income, and that IBR even allows for what will happen if you're temporarily without a job, the fact of the matter is that it is a vastly more humane system than ever it was 5 years ago.
Right, but not to be presumptuous, but when you went to law school, were student loans dischargeable under bankruptcy? I mean, that would be the ultimately humane solution, right?
Regrettably, that stopped just about the time I graduated.
Ah, shucks. Tough to be on the wrong end of that deadline.
That's true. Besides which, bankruptcy has always been a tough option in America. It's not that you can just walk in and walk out.
No, it's not a happy moment for sure.
Right. For a fiduciary to declare bankruptcy is a very, very, very big blot on one's record.
Professor, reformers take schools to task for failing to adequately help their graduates find jobs. But you say, quote, placement is no more the obligation of a law school than it is of music school, unquote. Now, there is an ocean of difference here between music schools and law schools. There's no regulatory body requiring a degree in order for musicians to practice their craft. Law schools are totally different in that sense. In the vast majority of states, you need a law degree to become a lawyer. Don't schools owe their students some obligation to not educate more students than there are jobs?
Well, that's a rich question with many ways to approach it. But let me first defend and then criticize my own analogy. I am someone who loves music, and I take that not as a flippant analogy, but one is very seriously apposite. For a musician who is competent and skilled, the opportunity to make a living as a musician is fundamentally essential and available because they're responsible for their own careers. Might be opportunities for a professor to make a recommendation, for information to be better available through the music program, but ultimately every person remains responsible for finding a job, finding ways to support not only the person, but also whatever other dependents the person may accrue, whether through marriage, family, or otherwise. That's still the way it is in law school. Now, law schools have worked very hard, as have business schools and other programs, to provide opportunities to get jobs, to provide information, to provide access, to facilitate something like a matchmaker between people who have jobs and not. But here is the fundamental mistake that is made by people who say that there are not enough jobs. Lawyers are uniquely capable of opening their own practices. Now, this has changed over the last 50 years. Before I went to law school, it was actually very common for a young lawyer who wanted to enter a practice to have to find capital, often borrowing it from family or friends, to buy into a practice. This is now rather uncommon. Frankly, most people are employed and then enter into a practice by being given a gift of partnership if they go that route. I have many students who have entered quite successful solo careers. They simply took the risk, had the skills, developed the friendships and the mentoring necessary, acquired their clients through hard work, through good marketing, and began practice. The idea that we must have jobs for our students is not only a mistake, it's a dangerous mistake. Because who will have the capital initially to fund a student at a very high salary? Only those enterprises that have a lot of capital for litigation. Now, the government is one, and that's off the table, I think, for a variety of reasons from this argument. But the others are basically the defense. They are large corporations and insurers who have a great deal of money that they invest in order to defend themselves from liability. And then a very few very successful plaintiffs' lawyers who will bring students in and who will fund them for a salary up front. This leaves an enormous number of people who might be able to serve others without an opportunity to enter into that service if they're only dependent upon having a job coming from that type of firm. That basically boils down cavalierly to big law. If big law is the basis for the entire American legal practice, then law firms have become the successor to the bar, and that is a mistake. I think big law does important things. I have great friends in big law. I practiced in big law myself. But the fact of the matter is it's only one half the bar. And the other half the bar is not well served by, I think, saying that that is the only mechanism by which people find employment. And it is wrong of law schools only to feed that form of service.
Professor, finally, reformers claim that the drop in law school applications is proof their critique of law schools is correct. You maintain it's merely proof that the criticism is scaring away prospective students. That criticism of law schools is a self-fulfilling prophecy. What do you mean by that?
Well, I do think that it is true that some portion of the students who have not come to law school have come as a result of the critics' efforts. That's absolutely certain. On the other hand, the bulk of the drop over the last 3 years in legal application, law school applications, has basically been the type of ordinary cycle that follows the return to employment, especially in finance and the professions. Now, most of the critics, in fact, I think Brian is very sensitive to this, most of the critics have expected that and have said, but this doesn't explain enough. How come that trend has continued past when the bubble might have already burst and then began to rebuild? Well, I don't think it was a bubble. I do think, however, that an awful lot of students who might have entered into law school have been scared from it by the critics themselves. I believe that the trends suggest, and I've engaged in a number of interviews and spoken with a number of other professors at other schools in other parts of the country and in other markets. I am by no means alone in suggesting that the criticism itself has created a false sense of doom for legal education, something like trade libel. And as a result, many students who would have been very good performers in law school and would easily have found employment have chosen not to go to law school because they've been scared away. Here's a simple illustration. It isn't, I think, a perfect illustration because no one illustration can absolutely represent a curve or a whole pattern. I ran into one of my former undergraduate students when I was at a restaurant a few years ago, probably a few months ago. She served me and I asked, well, what are you doing here? Why aren't you in school? And she said, well, I decided not to go to law school. My pre-law advisor told me there are no jobs, that students can't get jobs. And I asked her, well, weren't you going to go to Arkansas? She said, yes. And I happened to know her advisor. I said, did he know that our students had a 96% employment rate last year? No, he didn't. I checked with him later. He absolutely didn't, and she certainly hadn't been told that. The broad brush of criticism hasn't helped. There are things that we should do better, and indeed there are certain markets, especially in New York, that have suffered more than other markets. And certain students have gone out, have had lots of merit, and sought jobs and not had them. But this is not enough to explain why so many qualified students who decided not to, they're hearing the culture of complaint. And they're responding, I think, very reasonably, believing these people who say these things, even though those people are wrong.
Professor Stephen Sheppard, thank you very much for your time today, sir.
It's my pleasure, Lee. Thanks so much for this effort.
If you'd like to learn more about the issues we just discussed, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Lee Pacchia. Thanks for watching.